Please, my lord. Yes, Lordship, I beg to mention hearing item number 42. Item 42, my lord. Hearing item 42. Yes. If this matter can be listed after 3 weeks, my lord, it's a consensus prayer. Okay. On the joint prayer made by the Honorary Council for the parties, list this matter after 3 weeks, my lord. 3 weeks. Okay. I'm deeply obliged, my lord.
Lordship, I beg to mention a criminal petition, Lordship. Earlier advocate he had withdrawn the Vakalapnama. Now I have filed my Vakalapnama in this case, Lordship. This matter may be listed on 11th of June, Lordship.
11th June.
Yes, Lordship. I am not titled. Criminal petition 17 of 20.
Okay.
It is not listed today.
Okay.
Problem.
Please, Lordship. Lordship, I beg to mention item number 16. Here, I'm appearing for respondent number 3, 6, and 7. We have filed Vakalatnama this morning, Your Lordship.
Lordship, I'm for the appellant.
Okay.
Lordship, if the matter can, since the LCR is here, the matter can be posted for admission hearing after 2 weeks, Lordship.
What's this for?
Admission hearing
Okay.
after 2 weeks.
Let's pray for by the Honorary Council for the
16.
appellant. And you are appearing for the first time.
Second time, Your Lordship.
Okay, earlier already.
Appeared, Lordship.
Okay.
However, we have filed only the Vakalatnama
Honorary
this
Council for
morning.
the parties, list this matter after 2 weeks for admission hearing.
I'm for respondent, still respondent.
Okay, you are for,
1, 2, 4, and 5.
okay, then write this, this way. On the prayer of Mr. Procedural for the Honorary Council for the appellant. And you are for?
Respondent number 3, 6, 7.
Okay,
I, Jamir.
okay, I Jamir for 367 and Mr.
I'm for
Joe.
1, 2, 4, and 5.
1, 2, 4, and 5. And Mr. I Jamir for 3 and
You are three, for three,
3, 6, and 7.
3, 6, and 7, huh? List this matter after 2 weeks for admission hearing, huh?
Lordship.
Right.
Yes,
Lordship, I also mentioned item number 50 from the supplementary hearing, Lordship.
50.
50, it's a partner. It's a partner matter. Lordship is asks for the gist of argument from the councils. But Lordship, today I'm not ready for the hearing and submission of the
Next week.
next week,
Lordship, can I submit my written argument? I'm ready.
This is your.
I'm for the respondent.
Okay. Okay.
Item number 15.
Item 50,
Yes, I'm the respondent, for the respondents.
Mr. Fasego for the counsel for the petitioner.
Lordship.
When,
Lordship,
okay,
What?
4th June.
It's just for submission.
4th June.
okay, as prayed for by Mr. Fasego for the line counsel for the petitioner, list is matter on 4th June.
Lordship.
Mr. Deem Chen, line counsel for the
Lordship.
respondent, is also present. You want to submit today?
Yes, I can submit today, my lord. I'm ready.
On 4th June, I think it's okay only, on 4th June. Okay,
Obliged, my lord.
okay.
Lordship, may I mention item number 27?
Yes.
Lordship, can it, let the matter be listed after 3 weeks?
Okay. Is grateful by,
Lordship, I'm appearing for the petitioner.
you are for the petitioner? Okay, Mr. You look,
City rules.
okay, line counsel for the petitioner is present. Mr.
For
Yes,
the respondent.
line counsel for the respondent number?
Respondent, sorry. Respondent number 3.
No, 3. Is the moment, line counsel for the respondent number 3. Praise for listing this matter after
3 weeks. 3 weeks. 3
2
weeks.
weeks.
no?
3 weeks, 3 weeks, okay. The prayer is allowed, list this matter after 3 weeks, okay.
May I please, Your Lordship?
Yeah.
Your Lordship, I beg to mention item 29, Your Lordship. After hearing this, Your Lordship, this matter may be listed after 2 weeks, Your Lordship.
As
I've taken
grateful
the
by the
consent
line
of the
counsel for the respondent, list this matter, state respondent, list this matter after 3 weeks.
Your Lordship, and also item 30 to 38, these are analogous matters. This may be listed after a week, Your Lordship,
After,
after a week.
okay,
And Your Lordship, item 40, Your Lordship,
just a minute, 38, after 38,
30 to 38,
okay.
these are analogous matters.
So who, have you informed
Yes, I've informed the petitioner,
Okay.
Your Lordship.
Miss?
Yes, and Your Lordship, I also beg to mention item
Lara
40.
State Council. Praise for listing this matter after a week. Now, with the consent of the Lara Council for the petitioner. Praise for listing this matter after a week. The prayer is allowed, list this matter after a week. Okay,
Your Lordship, I also beg to mention item 40.
14.
Yes, 40. Your Lordship, this matter may be listed on 11th of June.
Have you informed the Lara?
Yes, Your Lordship, is present.
Lara Council for the petitioner, Mr. Fatizamir is present. Miss, her name, huh? Lara Council for the state respondent. Praise for listing this matter after?
On
11th.
11th.
Okay, on 11th.
Yes, Your
Okay.
Lordship.
Okay, is, no, he is also present, is prayed for by the Lana Council for the parties. List this matter on 11th June.
Your Lordship,
Okay,
if I may, I also like to mention item 17, Your Lordship. Here-
17?
Yes, Your Lordship.
Yes.
Your Lordship, here I'm yet to file my counter, so kindly grant 3 weeks time, Your Lordship.
Okay, Miss. Lana Council for the state respondent. Prays for
17.
the 3 weeks time to file counter. So the prayer is allowed. List this matter after 3 weeks.
Much
Okay.
obliged, Your Lordship.
Please, Your Lordship.
Counter.
Lordship, item number 8. In IA 48 and 2023, we were appearing for the applicant. We have instructions to withdraw the Vakalatnama, Your Lordship.
IA
48 of 2023.
So what about the other?
Your Lordship.
Lordship, he will be appearing.
Yes, in IA 48, we've been instructed to appear for the applicant.
They have
Item
the-
number 48,
You are appearing
48,
for the
applicant.
applicant, okay?
Yes, and I found my Bangla also, this one.
Okay, you have
They
filed,
will be appearing, Lord. So we would like to withdraw our wakalat nama. And our name may be deleted, Your Lordship.
okay, okay, so after they have withdrawn, so you have been engaged now, okay. Mr.
I, Jamir, Your Lordship.
Land Council for the who appeared for the appellant in I 48, huh?
Applicant.
Applicant, huh? Wants to withdraw. You are alone or,
Lordship, three of us, Lordship.
okay, alone there, wants to withdraw their wakalat nama. And, Mr. Iralo, huh? You have filed wakalat.
Yes, I found it.
Okay. Some said they have filed wakalatnama to appear on behalf of the appellant. As prayed for, the prayer for withdrawal of the wakalatnama, the prayer for withdrawal of their wakalatnama is allowed. Start. The name of the Jamil and
TB Jamir.
the TB Jamil are
R. Alamwati Jamir.
Jamil and I Jamil may be removed from the course, from the course, then from the course list and Mr. Iralo.
As reflected in the Bangla, the names will be inserted accordingly.
It was already reflected.
No, not yet. It's not in the file, man. I filed it this morning.
Okay.
Yes.
How many of them you are there? Iralo and you and who else
My senior also. My
Okay.
senior, I will have this.
may be reflected in the course list as a counsel for the applicant.
Applicant.
Okay.
Obliged, Lordship.
Lordship,
As prayed for by the Land Council for the party, list this matter after
3 weeks.
okay, 4 weeks, we'll be filing our
4 weeks.
written
after
objection
4 weeks.
to the report of the DC, Lordship.
Okay. After 4 weeks.
Much obliged, Lordship.
Yes.
Your Lordship, notice, Your Lordship.
Yes.
Lordship, here in item number 8, I-8 28 of 2023, we are the petitioner here. We are the applicant. There are 2 IAs for substitution
Okay.
and in,
But it is connected only.
yes, it's
This is
connected.
connected with 48.
Yes, it's connected with RSA 1 of, it's connected, but,
They prayed for listing this matter after 4 weeks.
after 4 weeks. Okay, I pray that my name may be also reflected in the
Your name
order.
was not yet reflected.
Yes, Lordship. If
Hey,
this
hey.
is IA 28, in IA 28 of
A
2023.
applicant,
Yes, Lordship.
you are,
Honbeni.
so there is a name, Joshua Saki,
Yes, Lordship.
you are for applicant,
Yes, Lordship. In IA 28 of
28.
yes, and they have mentioned IA 48 of 2023.
No. So in 28, they have mentioned some name of the advocate. There is a name of advocate. Your
Lordship,
name is there.
Lordship, they have mentioned IA 48 of 2023, and I'm mentioning IA
Yes. In
28.
against 28 also, there is a name of the advocate.
Yes, Lordship. Here I am representing. I am the
Your name is there.
yes, Lordship.
Okay.
Honbeni.
No problem there. Your name is already there.
Yes, it's already there.
Okay. So this will be listed after 4 weeks.
Yes, Lordship.
Okay. Is prayed for by the Land Council for the party. At least this matter after 4 weeks. Okay. Yes.
My bless your lordship. Your lordship, I beg to mention item number 22.
Item
22, your lordship.
22.
Yes, your lordship, we are yet to receive instruction of filing our affidavit, so I pray that 4 weeks time be given to me. And for the respondent one, your lordship.
Okay. You are Miss
LB Junior, Your Lordship.
Land Council for the petitioner is present. You are appearing
Lordship, I am for respondent number 2 to 5.
2 to 5 and you are for?
Respondent one, your lordship.
Have you filed your affidavit?
Yes, Lordship, I have filed my
Okay.
affidavit on the last date.
Mr.
Sipom, your lordship.
2 to 5, you're Mr.
KV Nagi on
Right,
behalf
oh.
of SGTI.
Land Council for the respondent number 2 to 5 are present. And Mr. Your
Sipom, your lordship.
for respondent number?
Respondent one.
Okay. Okay, respondent number one, the land and council for the respondent number one. Praise for further, how much time?
4 weeks, your lordship.
4 weeks time to obtain necessary instruction and to file affidavit in opposition. Okay,
Lordship, let the interim continue, Lordship.
next para, huh? The interim order passed earlier shall continue till the next date. Okay.
Apply to Lordship.
Oblige, your lordship. Your lordship, I beg to mention item number 23.
20,
23, your lordship. Your lordship, I have direction from the respondent number 3. So 2 weeks time be given to file my Vakalatnama and affidavit, your lordship.
have you informed the petitioner whether the petitioner is present?
Yes, your lordship, consent has been taken.
Okay, Mr.
Sipom, your lordship.
Land and council for the appearing for
Respondent 3.
respondent number 3 with the consent of the land and council for the petitioner. Praise for
2 weeks, your lordship.
2 weeks time to file. F.
To file Vakalatnama and affidavit.
Okay. To file Wakalatnama and
Affidavit, your lordship.
affidavit. The prayer is allowed. List this matter after 2 weeks. Okay.
Oblige, your lordship.
Yes.
Please, your lordship.
Yes.
Your lordship, I beg to mention item number 9.
Item.
9. Your state is yet to file affidavit, so kindly grant me 3 weeks time, your lordship.
Yes. Control notice file.
Yes, your lordship.
Whether the petitioner is present.
And for the state respondents, your lordship.
The petitioner.
I've taken the consent from the
Or taking
petitioner, your
consent.
lordship.
Okay, Miss. Land and council appearing on behalf of the state respondent. Praise for. Further,
3 weeks, your
3
lordship.
weeks time to file counter affidavit. The prayer is allowed. List this matter after 3 weeks. Okay.
Your lordship, similar prayer for item number 11 also.
11. Same. Huh? Similar order. Huh? Okay. In here, then her, the her present may be, Luzino's present may be recorded. Huh? Miss Luzino, land council for the petitioner is present. And then her prayer. Huh? Same. Okay.
And your lordship, item number 21 also. On behalf of Tiba, kindly grant 3 weeks time to file affidavit.
21.
Yes, your lordship, 21.
How much time?
3 weeks, your lordship.
You are ready. You're for the petitioner.
Yes, madam.
Okay. Mr.
Lordship, there is an interim. Interim that
Okay.
will continue.
You are Mr.
Ali also from Lordship.
Okay, land council for the petitioner is present. And Miss land council appearing on behalf of the state respondent. Praise for the 3 weeks time
Yes, your lordship.
to
File counter, your lordship.
file counter affidavit. Stop. The prayer is allowed. List this matter after 3 weeks. Okay,
Oblige, Lordship. May I please roll, Lordship?
yes.
Lordship, I beg to mention admission item 5, 6, and 7. Lordship, kindly adjourn this matter for 3 weeks
You are for the
for the
okay, petition.
applicants, Lordship.
Okay. Mr.
Ali also from Lordship.
Land council for the petitioner. Praise for
Adjournment, Lordship, for 3 weeks. For 3 weeks.
praise for seek for adjournment for 3 weeks, to which Miss land council for the respondent has no objection. Stop. Accordingly, the prayer is allowed. List is matter after 3 weeks. 5, 6, and
7, my lord.
7.
Yes.
Okay. Yes, this is connected, huh? Okay.
My lord, I also beg to mention hearing item number 39.
Item,
Here we have submitted an adjournment slip.
item,
39, Lordship.
yes, there is adjournment slip.
Yes. Kindly list this matter after a week.
Okay, as prayed for by the land council for the party. List this matter after
A week, Lordship.
a week. Okay.
Must oblige, Lordship.
I mean, you're also allowed to mention item number 3, my lord, on behalf of Akin Risum.
Item,
Number 3, item number 3.
yes,
My lord, if this can be listed after a week.
you are for the petitioner. Okay,
On behalf of the petition.
Lordship, I'm for respondent 2.
respondent,
2.
no objection. Okay. Mr.
Taka Kichu on behalf of Akin Risum.
Okay, appear on behalf of Akin Rishon, land council for the petitioner. Praise for listing this matter after
After a week, my lord.
a week. Miss
Nancy Lota.
Nancy Lotha. You are for respondent number 2.
Yes, your lordship.
Okay, appear on behalf of the respondent number 2 and has no objection to stop. Accordingly, the prayer is allowed. Release this matter after 3 weeks. Okay.
May I please, my lord? Lordship, item number 28. Lordship, may it be listed after 2 weeks, lordship. I've taken the consent of the appellant counsel.
Lordship, let it come up after 3 weeks. Lordship.
Okay. Mr.
Siddhi Ramsum for the appellant.
Lani counsel for the appellant is present. Stop. Mr. Angami Lani counsel for the state respondent. Prays for listing this matter after 3 weeks. The prayer is allowed. List this matter after 3 weeks. Okay.
Much obliged.
Maybe Lordship.
Yeah.
Lordship, I beg to mention 15:15. Lordship, I'll file my affidavit today, Lordship.
Objection not yet filed. Yes.
I'll file today, Lordship, this morning.
File.
Lordship, I've sent a copy to the petitioner also. Lordship, if the matter came up next week.
Fixed for admission hearing. Even without reply, Lordship, I'm ready to argue, Lordship.
Lordship, may kindly grant me a week, Lordship. My senior is not keeping well, so.
Okay. Mr. What is Lani counsel for the petitioner is present? Mr. Seko Forte, Lani counsel for Seko Forte submits that he has filed his objection today itself
Lordship.
and prays for listing this matter after.
After a week, Lordship.
Lordship, on 6th, did may fix. On 6th,
Six.
next week, Lordship. This Thursday.
Okay.
For admission hearing, Lordship.
Is it okay?
Lordship, Lordship.
Okay. File today, so as prayed for by the Lani counsel for the party, list this matter on 6th. For admission hearing. Okay.
Obliged, my Lord.
Obliged, Lordship.
May I please, my lord? My lord, I beg to mention admission item number 1 on behalf of Mr. Sandiangar. My lord, my senior Sandiangar is having some difficulties, so this matter may be listed on Monday.
Monday.
Fix, yes, fix on Monday.
This is a part-heard matter, your lordship.
Okay. Which case you are talking about?
Item 1,
Wait, you're getting it registered when?
fix on Monday.
49. Yes, these are connected, yes.
We have also filed a petition
Yes,
on behalf of the state
yes,
for cancellation of this bail
okay.
of the accused persons.
Hmm.
Instructions were given by the law department to the concerned council to file it
Hmm.
way back in February. And by the time since they filed it,
Okay,
she was under the impression the relief is the same. So inadvertently, she did not file it. She expressed her regrets and we are looking at the matter. The matter came to our notice, we immediately asked for filing of that lead application for the same relief, which is cancellation. We have come here specifically for that. Now, since the first matter, which is going to be heard,
Hmm.
it is also the same matter
Hmm.
filed by the private party.
okay,
Our both matters can be listed together.
okay.
Now,
And probably in your matter, notice need to be issued to the respondent
please.
because since it is for a cancellation, so notice need to be given to the,
Yeah, in fact, we are given advance,
or, okay, they have acted.
we are given advance 50 days. You got advance copy. They have received the note advance.
I have received instructions to appear, my lord. I'll be filing my Vakalatnama.
Okay,
Now, in this second application, it has been filed under 492, 482, 227.
Hmm.
So I need to reply to that, man.
okay.
I need to reply to that.
So that has been listed as, not listed or listed.
It is in the motion supplementary list,
49.
supplementary list, item 49.
Yes, yes, 49.
49. I'll be filing my authority today, my lord, during the course of today. And some time can be given to me. I pay for some time to file my affidavit.
So when this then matter one and this would be.
It can be clubbed together, Your Lordship. It can be clubbed together, it's all right, I don't know. It
Okay,
can be
well-
clubbed together. And then
When do you want this?
can I be given 3 weeks' time to file an affidavit?
My lord, this is a bail application for cancellation, which involves very serious issues. But since my learned friend wants to file a reply, I have no difficulty in that. Keep it after today's what day, 20?
Today is 30.
Could it be kept on 13th or something? That's all right?
No. I need some time.
We cannot,
Why?
because we have.
That's okay, that's no problem. 5 hours it takes to reach here.
When?
No, I have to go out of station.
What date you want?
Sometime in the third week of June.
Third week of?
June.
49.
No, not third week, madam. Madam, this is a
Otherwise,
very, very serious issue.
I substitute
So then,
this given to me.
49.
Which date you want to put? 24th is what?
So in the
24th, so fix on the 24th. We'll have it on 24th together.
Yes.
24/6.
Not 20, could it be kept on 23rd or 25th? I don't know.
24th is Sunday, no, Sunday.
25th.
25th is fine. 25th June.
Yes, then in item 1, right, huh? So item 1, who is praying for? So then these both will be listed together then?
Yes, ma'am. Both together.
Okay. So in the item 1, huh? Who prays for?
The petitioner,
Petitioner.
the petitioner prays for it.
Okay. Item 1, land council for the petitioner. Why you want, where is the petition? Okay. You are mentioning on behalf of your senior.
Sentiang,
Okay. Appearing Mr.
Noklay.
Land council. For the petitioner.
Is it 50 dollars? Or you want it on 23rd?
Prays for listing this matter. No. Prays for adjournment of the case. Huh? As the main counsel is, where is Mr. Sentiangar? He's out of station.
Out of station, my lord.
Okay, out of station staff. Huh? Is prayed for by the land council for the parties. List this matter on 23rd. 25th June, 25 June. Okay. So in 49, then
22nd,
22nd is Saturday.
21st.
20?
21st.
25th is Tuesday. 25th is Tuesday.
So one day on 21st, which will be convenient.
21st is Friday, probably Friday.
21st is Friday,
Friday.
then keep it on 20th.
No, I have some problems. I have to be on station.
Somewhere we have.
No, I've not been stationed. Please, 25th, my lord.
Then if that is so, then keep it next week. I'll come and do it.
No, I have filed my reply.
This is a-
Some allegations have been made.
File a reply, no
Some
problem.
allegations have been made.
Yeah.
I require some time.
That's all right. You have only replied to that.
Oh my God, with all due respect to the letter advocate general, he cannot bulldoze his way
The
his way through the
circumstances in
proceedings.
which they bulldozed the court and got this, I'm going to
Who
explain.
bulldozed?
Yeah, that I'm going to explain.
Who bulldozed?
That's why I keep it on a short date. Next week.
25th. That is why it is necessary that I file my affidavit, my lord.
Yeah.
That is why it is necessary that I file my
That will
affidavit.
be kept next week. Any date convenient to your lordship. Maybe Monday,
And
Tuesday.
in
no
fact, your lordship,
Just
Monday or Tuesday.
in fact, your lordship,
Yeah.
File it.
serious allegations have been made.
Definitely.
But the person against whom they're making those allegations is not a party.
Need not be.
How is that possible?
Need not be. You don't worry about it.
How can you condemn someone behind his back?
That's what the order was passed behind our back.
You are not condemned. You are condemning someone behind his back.
The whole thing will come out when we argue
Okay,
this case.
we'll have to decide when,
25th, my lord.
Yeah, not 25th.
25th, my lord. I require at least 3 weeks' time.
Keep it before 24th, man.
Otherwise, 24th. We have a case on the 24th.
Keep it on.
We have a case to get on the 24th. What is the problem of having on the 24th?
any difficulties on 24? The other one, the item 1, we are fixing.
Which is
Item 1, we have the 25th. So any difficulties on 25th?
I-
Okay,
That's why I thought if it could be had on 21st.
come to some consensus date, then if you want the date to be fixed,
Your Lordship, I have,
second week.
I
I
have,
have, we can keep it on 24th, the date on which you.
Yes.
24th, which is okay?
yes, Your Lordship.
Okay, so the earlier one also make it 24, huh? And in this case, just a minute, huh? But, okay, Mr. Lannis, advocate, they're filing through you, okay. General. For the applicant, huh? And also Mr. Jimomi, who would appear on behalf of the respondent number. the
All the
respondents, all the respondents, huh? Respondents, staff, huh? Para. This is an application under section 439 to renovate section 482 of the Code of Criminal Procedure, renovate Article 227 of the Constitution of India for cancellation of bail granted to the accused persons. Cancellation of bail granted to the accused person on 22/12/2023 by the Line Principal Session Judge Dimapur in IA bail number 755 2023 arising out of GR case GR number 787 2023 Dimapur East PS case number 292 stroke 223 under section 302, 323, 325, 34 IPC. Staff. Issue notice. Returnable by 24th, sorry, 24th, June. Since Mr. Zimomi appeared and accepted notice on behalf of all the respondents, no formal notice need be issued. Okay.
Requested
Please.
copies, my lord?
Mm.
Requested
Okay.
copies.
So, however, the petitioner herself furnish requisite extra copy to the land.
One copy. I need to give
To counsel for the respondents during the course of the days. Bill, staff, this is matter on 24th.
They also mention in the event I want to file any brief affidavit before that date, I will be given the verdict. After receiving this, if required.
Okay, the land counsel for the petitioner. But, okay. Submits that he may be given liberty to file additional affidavit
If required.
if required.
And
The
they
prayer is-
file it within 3 weeks or whatever
Okay,
is the
the
time.
prayer is allowed.
Much obliged.
May it please your lordship. May it please your lordship.
Yes,
Lordship, I beg to mention item number 41, your lordship. 41,
item.
41, your lordship. Lordship, I pray that the matter be listed
41,
up
just-
next week, your lordship.
Just a minute, huh? 41,
Admission, your lordship. It's in hearing, your lordship.
yes, 41,
It be listed next week, your lordship.
okay. You are for,
As per the states.
okay, Mr. Mr.
M. Solo, your lordship.
M.
Solo
Solo, Line Counsel for the
petition,
petitioner. Praise for listing this matter after a week.
lordship. A week.
After a week, huh? To which, okay. You have already filed, okay, this is for hearing.
For
Okay,
hearing, your lordship.
okay, Miss,
On behalf of Livika.
okay. He is present on behalf of Livika Line Counsel for the state respondent, huh? It's great. And the prayer is allowed, list this matter after a week, okay.
Lordship. Lordship also beg to mention item number 43, 44, and 45, your lordship. Lordship, pray that the matter be listed after 2 weeks, your lordship.
Okay, similar order, huh? You are appearing here also?
Lordship on behalf
Okay.
of Tipa.
2 weeks.
Yeah, says that prayer not objected, huh? then thereafter, list this matter after 3 weeks, okay.
May I please, Lordship, I beg to mention item number 14. Kindly grant 3 weeks time to file my affidavit.
Miss,
Petitioner.
so, Lara Council, Lara Government Advocate for the state. Praise for father, how much time?
3 weeks.
3 weeks time to file counter affidavit.
I've taken the consent of the petitioner.
Okay. She has also taken a consent of the land council for a petitioner. According, the prayer is allowed, list this matter after 3 weeks, okay.
And Lordship, item number 10 on behalf of Divika, similar prayer.
Item 10,
Lordship,
here also you have taken consent of the other side. Okay, you are
For the petitioner, Your Lordship.
Mr.
Benison Visual.
Benison, we show. So land council for the petitioner is present. Miss Swenson appearing on behalf of Libika, land council for the state respondent. Praise for listing this matter after
2 weeks.
2 weeks.
Lordship.
Okay, the prayer is allowed. List this matter after 2 weeks. Okay.
Lordship, I also beg to mention item number 19 on behalf of Vizulo.
Item 19.
Lordship, kindly list this matter too.
Here you are appearing on behalf of. Here you are appearing on behalf.
Lordship, my apologies.
Okay.
May I please, Your Lordship? Lordship, I beg to mention item number 12 and 13, Your Lordship.
19 not mentioned. No? Okay, you are mentioning
12 and 13, Your Lordship. Lordship, here I'm appearing on behalf of Apila, Your Lordship. For respondent number 9, Your Lordship. Lordship, we have recently been implemented, Your Lordship. If
you have filed just filed wakalat nama.
yes, Your Lordship, we're implemented just recently, Your Lordship.
Okay, you want to file counter.
Yes, Your
You are
Lordship.
appearing on behalf of respondent number 8.
9, Your Lordship.
9 is
The agricultural
Private.
officer, Your Lordship.
okay.
Lordship, we're here to get instruction, Your Lordship. If 3 weeks time be given.
Respondent number 10 in WBC 321 and respondent number 9 in 236.
Okay, you are miss.
It's a correct.
You are for okay.
I'm
Land
correct,
council for the
petitioner.
petitioner is present. Okay, Mr.
Cancellation, Your Lordship. On behalf of Apila Santam, Your
Put it,
on behalf of Apila Santam.
okay, on behalf of Apilasa for land council for the respondent number 9.
Yes, Your
Praise
Lordship.
for
Respond number 9, Your Lordship.
submit that they have just filed wakalat nama and praise for some time to file
Affidavit.
affidavit. The prayer is allowed. List this matter after
3 weeks, Your Lordship.
3 weeks. And then the similar order in item 13 also, but here for respondent number 10, huh? Into 13. This is with only that 12, 13 is with 12. Okay,
9 important.
but here respondent, see, he is appearing on behalf of respondent number 10. Okay,
Lordship, Marshal.
yes.
May I please, Your Lordship? Lordship, I beg to mention item number 25, Lordship.
Item
25, Lordship, on behalf of Alamopang, Lordship. Lordship, here's an instruction to appear for respondent number 1, 2, 3, 4, 6, and 7. So, Lordship, kindly list this matter after 3 weeks.
petitioner, Mr.
Kambai. Kambai.
Kambai
Appearing on behalf of Pagin Rizavo.
appeared on behalf of
Pagin Rizavo.
Mr. Pakin Richabo, Land Council for the petitioner. He is present. Mr.
Mr. Gajishi, Lordship, on behalf of Alamopang, Lordship.
Anangapa Land Council for respondent number 1, 2, 3, 4,
Except for respondent number 5.
6, and 7. Praise for. How much time you prayed?
Lordship, 3 weeks time.
3 weeks time to file.
Lordship, Bakalat Nama.
Okay. You're appearing for the first time
Yes, Lordship.
to file wakalat nama. Only to file wakalat nama 3 weeks.
Bakalat Nama in necessary affidavit, Lordship.
Okay, and necessary affidavit. The prayer is allowed. List this matter after 3 weeks. Okay.
Please, Lordship.
Lordship, I beg to mention item number 46 on behalf of P. Suren. Lordship, the main counsel is out of station as he's facing his personal problems, so the matter may be listed after 3 weeks.
Okay. You are Mr.
Kampai.
Hmm?
Kampai, appearing on behalf of P. Suren.
Okay. Appearing on behalf of P. Suren. Sorry, Kamba submits that Mr. P. Suren, the main counsel is out of station, and pray for listing this, and pray for adjournment. Is prayed, list this matter after
3 weeks.
3 weeks. Okay. Yes,
May I please, my lord?
yes.
I also beg to mention item number 26, hearing 26, on behalf of Santiago. Item number 26. My lord, my senior Santiago is out of station, so this matter may be listed after 2 weeks. my lord.
Okay. Mr.
Noklai M.
Appearing on behalf, sorry. Appearing, submit says is senior Mr. Santiago is out of station and prays for adjournment of the case for 3 weeks. 2 weeks. Okay. Mr. Angavilami Council for the State respondent is, sorry, revision, no? PP is present, stop. Is prayed for by the Lami Council for the, appearing on behalf of the petitioner. List this matter after 2 weeks. Okay.
May it please your worship. My lord, I beg to mention item 19, 20 and 24.
19,
20 and 24.
20 and 24.
24, yes, my lord. I'm yet to receive instructions. They
Okay.
pray that 3 weeks time
They
is
are-
granted. It's almost analogous
wait.
method.
Almost
Yeah,
another.
Your Worship.
Okay.
Item 20
20,
and 24. similar.
19,
19,
20 and 24.
20 and 24.
Yes, my lord.
Okay. You are Miss
Pickets or no?
Land Council for the petitioner. In all the case, you are for the petitioner.
Petitioner.
Okay, Land Council for the petitioner is present. Okay. And Mr. Chu,
LT Sanctum, additional AG, your worship, for the state.
for the state, prays for
3 weeks time, man.
3 weeks time to file,
To receive instructions, your worship.
to obtain instruction and to file necessary affidavit.
Yes, ma'am.
The prayer is allowed, list this matter after 3 weeks. In all the case, separate, huh?
Worship.
May I please, Your Lordship?
Yes.
My lord, I beg to mention item number 47.
Item,
Number 47. Kindly
47.
fix this matter after 2 weeks.
when do you want?
After 2 weeks.
After 2 weeks. Miss
Honbeni.
Land Council for the applicant,
Opinion, Mr. Lordship.
prays for listing this matter after 2 weeks. Prayer is allowed, huh? Mr. Angami Land PP is also present. Staff, huh? Prayed, list this matter after 2 weeks. After 2 weeks?
Yes, Lordship.
Okay.
Obligement.
May I please, my lord?
Yes.
Lordship, item number 2.
So in 47, you are appearing, no?
Yes, yes,
Okay, okay. Item 2.
Yes. Lordship,
Yes.
here, before we
The
did not able to,
paperwork is ready.
yes, yes. Lordship, here before, we could not able to take care of one provisions. I think this matter has to be listed before division bench.
Is it?
Yes.
Challenging what?
Now, the respondent was acquitted under 302 and we're challenging the acquittal of under section 302, Lordship. And as per section Gauhati High Court rules chapter 2 rules 7C 7B, it has says that let me read, Lordship. All matters, a division bench for the hearing, the division bench for the hearing of cases of appeal, so and so, and so. Then comes B, all matters where sentence of death penalty, imprisonment for life, or sentence of imprisonment for a period of more than 10 years has been awarded shall be heard by the division bench, including the relevant point, appeals and revision against acquittal arising out of cases tried under section 302, Lord.
What? rules. Rules.
Before we have overlooked the later part of the include
Mhm.
of the sentence. But
This was filed by state.
yes, yes,
Okay.
yes.
7A,
Yes,
7B,
B. Yes.
all matters where sentence of death penalty, imprisonment for life, or sentence imprisonment for period more than 10 years. This is a revision.
No, Lordship, appeal. Now here in this case, the case was tried under 302 and some other
You are
section
mentioning item
2. I think 2.
against acquittal. State has filed
Preferred appeal against the
appeal. Yes.
acquittal under section 302, Lordship. He was acquitted under 302 and convicted under 304. So he
This is only conversion of. So the 302 they have brought down to 304.
yes,
302 into 304.
yes,
So you are challenging that it should be convicted under 302.
yes, yes.
Let us see let us see. Confirm
Lordship, Lordship,
if it is to be listed before the division bench.
Lordship, Lordship.
Just a minute. Revision against. Including appeals
Yes, appeals.
and revision against acquittal arising out of
Yes, tried.
cases tried under section 2. Okay,
Yes, yes.
that is correct.
Yes.
Where is that? Just a minute,
Lordship.
We'll pass order then. Is there any other matter? 3 minutes that will be taken up. Then, this will be, we'll pass order.
Lordship.
Okay, not in the men's. Okay,
Lordship.
let the matter be called for. And the other probably, we are going to take up the other matter. Are we going to take up the other matter?
We have item number 4. It
Okay.
has been fixed for admission here, Your Lordship.
And one item 48 for motion.
Okay, this will be taken up.
Yes.
Yes, Lordship, we are ready.
The Lordship can say 2. The Lordship has been
We can,
sitting
yes,
since
we
10:15.
can, we can take it up at 2 o'clock.
At 2.
Yes.
Say 2:10. No?
All right.
Yes, yeah, all right.
Oh,
Right.
No?
Mention. Number 46, mentioned. 46. Wait,
3 weeks.
3 weeks. Petition of order. Okay.
All this. From the supplementary request for motion, item number 48.
I'm seeking compliance of the order dated 25th July 2023, page 12.
So direction was for,
Direction was to a direction to the DC Dimapur
okay,
to conduct first for the petitioner to file a representation, and then after that the DC to conduct a spot verification. But that has not been done. As far as the petitioner is concerned, they have filed the
within
representation.
15 days.
Yes. So cumulatively, the DC was supposed to complete all the exercise by within 2 months.
Okay,
No, this has not been complied with.
you have issue reminder.
Yes, we have issued 2 reminders, or in fact 3 reminders.
Okay. Will issue notice?
Yes.
Mr. Iralo, Land Council for the petitioner. Para. This is an application under section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India for non-compliance of the order and direction.
Order dated.
Order dated 25/7/2023, passed in WPC 70/2019. Start. Para issue notice returnable by 4 weeks. Okay, start. How many respondents are there?
Only one. The Deputy Commissioner Dimapur.
Only Deputy Commissioner. the petitioner shall take steps upon the respondent by a registered post with AD within a week from today. List this matter after 4 weeks. Okay.
For admission, item number 2.
Mr. Zumomi. Naran PP.
Angami, Your Lordship.
Yes, fine. Angami. Are, what happened? Usually it comes.
It's all right, it's all right.
Zumomi and Angami. Regular appearance. Angami Naran PP. So what about the earlier the respondent appeared?
Yes, he was here.
Okay. Conviction is under 304.
304, yes.
Okay. I thought that it was in the quantum only. So your challenge is
Both the sentence as well as the quantum.
so the
Yes, just approximately.
sentence is under section 304 only.
Yes, yes.
304 part 1 or part 2? No.
No.
Let us see. Because let us come to the last part of that. Where is the judgment?
Page.
Thirty 133.
This is a quantum.
So
I think no specific mention was made.
sentence rigorous implementation with the fine of rupees for the difference. No specific mention.
No, Lordship. In other four sections also, it was convicted, but we are confined to only the first section, Lordship, 302 in our appeal.
So where let us see once the justification that how he brought down from 302 to 304. The operative portion of that. It will be issue number 2, B. The respondent need to appear, I think.
It's not objecting actually, but
He was here in the morning.
he was here, but well, in that case, we proceed again to tomorrow if my lord can accommodate.
Tomorrow we can take up.
Yes.
So his presence is necessary. So he may raise some objection. So I also haven't seen the judgment in there. So you also can read the judgment. Yes. So how it brought down, and then the punishment is, if it is under, trial was of course under 302, but then
Yes.
it brought down to the 302 with a certain justification. If it is 304 part B,
Yes.
then 10 is also more, so it can be lesser. But in 304 part 1, then of course the minimum it will go to 10 years also.
Yes.
Let us see. Okay. As prayed for by Mr. Angamilana PP. List this matter. Tomorrow we have already listed. So Monday?
Lordship, in that case, Tuesday.
Tuesday, okay, Tuesday, next Tuesday. Listed again on next Tuesday. Tuesday is which day? What date? Fourth. Okay. It will listed on 4th. Okay. So this was, what was the provision?
Chapter 2, Rule 7 plus B.
Chapter 2?
Chapter 2, Rule 7.
Chapter 3?
Chapter 2, Lordship.
2. Rule
7.
B. Okay. Yes. So rule, I got rule, no? Okay, I have to go through this. Yes, any other?
For admission, item number 4. May it please, my lord.
Yes.
My lord, allow me to slowly take my lord to the facts of the case. There has been a lot of developments, and it is a case pertaining to 3 writ petitions. I'll just briefly state the facts, my lord.
Okay, just a minute. This is
My lord,
criminal petition.
Yes. My lord,
Under?
I'll be primarily relying on the criminal petition and one additional affidavit. For the
Additional
complaints of
affidavit
this
also you
court.
have filed.
Yes, my lord, incorporating the entire criminal
Have we
complaint.
heard earlier? No.
No, lordship. This is
Not
the
yet.
first time before.
Okay, first
this
time.
honorable
Okay.
court.
So this is under 482.
Yes, lordship.
Quashing petition.
Yes, lordship. Allow me to state the facts, my lord.
So offense was under 30.
Primarily 499. Defamation, lordship. This is a case of defamation.
Okay. No, that have committed offense under section 34, 109, 117, 120B. Okay, 500. Okay. Yes.
Now, lordship, at the outset, this criminal petition arises out of writ petition number WBC number 340 of 2020. So it is a part of
Arising out of?
WBC number 340 of 2020.
Yes.
Lordship. So the facts is like this, my lord. The genesis is like this. We filed the petitioner's hearing. We filed a writ petition in this honorable high court, lordship, which is numbered as WBC 340 of 2022.
Okay.
So in that WBC number 340 of 2022, the present respondent is arrayed as respondent number, is one of the respondent in the writ petition, lordship. So the writ petition was filed challenging the appointment of the present respondent number 2, along with 30 others, saying that they were appointed without qualification and without advertisement.
To the post of?
To the post of assistant professor, lordship.
Okay.
So now, my lord, so the criminal complaint was filed alleging that in the writ petition, in the pleadings, in some of the pleadings, my lord, we have defamed her. That is a simple allegation in the criminal complaint.
You have been defamed.
Yes, we have defamed her
Okay.
through our pleadings in the writ petition in WBC number 340 of 2022. My lord, I'll take you to the relevant portions, but lordship, it is also pertinent to mention that lordship, prior to filing of WBC number 340 of 2022, the some 19 petitioners along with the present petition number 3, they have filed two separate writ petitions challenging the same appointments of 175 assistant professors.
Okay.
Now this honorable court by order 666 of 2022 dismissed the petition on maintainability without entering into the merit of the case, while granting liberty to the petitioners to file appropriate petition. So after the disposal of that, we have filed an RTI. The RTI is, my lord, let me take, this is very important. The RTI is at page 37 of my criminal petition, lordship. My criminal petition.
This is listed in which what column?
Admission, lordship.
Admission, sorry.
Yes, lordship. It is for admission hearing. If my lord peruse page 37, annexure B.
This is additional affidavit.
Yes, that will be the additional affidavit. The criminal petition will be a slightly slimmer one. Yes, lordship. Page 37, lordship.
37.
Yes. So after the disposal,
37 is
RTI reply, lordship.
RTI.
Yes, 16th November 2022. This is this date is important, lordship.
Yes.
16th November 2022. So the two petitions were disposed of on 6/6/2022, dismissing the petition on maintainability without entering into the merits of the case. While
have you annexed those order also?
Lordship,
have you annexed those order also?
Yes, everything is there. I'll take my lord.
Okay.
Just briefly summarizing.
Yes.
So now after the disposal of the earlier writ petitions, we filed an RTI for clarification. With due diligence, we have filed this RTI to file appropriate petition. So here we have asked for, in this RTI, we have asked for those assistant professors who were appointed without qualification and without advertisement.
Without qualification and
without qualification and without advertisement, too, lordship.
Okay.
So the state respondents have replied, and then at page number 43, my lord, the present respondent, Srimati 43.
Okay.
43. So the serial number 143 is the present complainant, respondent number 2 herein in the criminal petition. So here, Srimati Rukono is teaching at SCTE, State College Teachers Education, Kohima. Lordship, this is important. State College Teachers Education and qualification, they have given MA and NET. So MA and NET is the qualification required for assistant professor to teach in colleges. Whereas for State College of Teachers Education, the service rules provides for a different qualification, which is Masters of Arts in Education with B.Ed or Masters of Education.
Okay.
NET was not required. So, but the state respondents had clearly stated MA and NET only. So, because of that, we have also included.
Or MAd.
Yes, because of that, we have also included her in the writ petition which is pending before this honorable court. Writ petition number 340 of 2022. So the simple matter is, my lord, the respondent hearing the complainant, because of the pleadings in WBC 340 stating inter alia that she is not qualified and she was appointed without advertisement, she is aggrieved and she filed without coming to this honorable court, she filed a criminal complaint in the Court of Judicial Magistrate First Class Kohima.
Okay.
The case number is criminal complaint case 1 of 2023, my lord. So that is the factual position of this case, my lord.
Case
Now-
taken cognizance of? No.
No, lordship, I may now take you to the relevant annexures, my lord, before I come to my submissions, lordship.
Whether the case is admitted?
Yes.
Yes, my lord.
Admitted.
That's what, that is our.
Then it will have to be listed on hearing, and detailed hearing would be required then
No, my lord, it can be disposed of at admission hearing.
at admission stage. If it is admitted, why it has been listed in the admission column then?
It has not admitted my.
But it was heard for 2 times, and then it was
Again listed in the.
Yeah. So now, my lord,
Now,
it's
it appears that you have, I think we have to list it hearing only.
if my
Because
lord,
pleadings are if the pleadings are
Yes.
completed.
Pleadings are
Pleadings
complete, but the matter may not take much time,
Yeah.
so we would be obliged if matter can be taken up for admission hearing. It's not a
at
lengthy matter also.
admission stage, it can be
Okay.
disposed of, my lord, if my lord is okay with it.
Okay, let us see.
Yes. My lord, I may just straight away take you to the writ petition, the writ criminal complaint, lordship.
Because today we have a meeting.
Okay.
The brief was not provided with
Yes,
us.
we've been informed.
And we have been just provided this morning of the, I've seen the brief, the cover, not open also.
Yes.
Full court meeting, brief need to, so that's why today.
My lord, we can keep it as,
It doesn't take much time, then we can try.
we can keep it as part heard, and then we can finish it on
Okay.
Monday or Tuesday.
Matter has not even started.
Okay.
It better not be kept as part.
Yes.
Hmm?
I mean, we can try today, and then if we cannot finish
us
it, we
see,
can
let us see.
continue Monday or Tuesday.
So all the respondents are present?
Lord, Worship.
Okay, okay, let us try.
Yes, my lord. So now, my lord, I will be referring to the additional affidavit for
Yes.
convenience sake, lordship. The criminal complaint is, the impugned criminal complaint is in the additional affidavit, lordship. Now, my lord, the criminal complaint is at page number 8, my lord.
Yes.
Yes, the relevant section is, my lord, is well versed, 34, 109, 117, 120P, and 500 of the Indian Penal Code 1860, my lord. Indian Penal Code 1860, my lord.
34.
Yes.
109.
109.
What is 109?
117, 120B, and 500 of the Indian Penal Code, lordship, IPC.
What is 109?
It is 109 is, my lord, punishment for abatement. If the act abated is committed in consequence and where no express provision is made. 117.
Yes. Abating
Yes, lordship.
commission of offence by the
Yes,
public
lordship.
or by more than 10 persons.
Yes, lordship.
Yes.
Yes, now, my lord, I want to take my lord to the complaint where they have said that we have defamed her, my lord. In the criminal complaint, my lord, page number.
This was filed by only one aggrieved person.
One aggrieved person.
Okay.
Not the rest.
So not the rest of
Not the rest, just one aggrieved person.
Okay. Yes.
My lord, page 18 of the additional affidavit, paragraph number 17.
Yes.
May I read, my lord? That for the context, the relevant sentences appearing in paragraph number 9 of the writ petition are extracted herein below, and the imputations defaming the complainant are emphasized with underlining. To that effect, at paragraph 9, this appears in paragraph number 9 of the writ petition.
Yes.
To that effect, as per the
Nine of the
writ petition.
okay.
So to that effect, as per the list, the respondent number 44 to 34 do not possesses the minimum requisite qualifications to hold the post as mandated by UGC guidelines issued from time to time and the Nagaland Higher Education Services Rule 2015. So the underlined lines are the alleged amputations that the respondent is aggrieved.
Okay, so
Yes, ma'am.
combined, we mentioned that serial number, respondent number 4 to 34
34.
do not possess it.
Yes,
The minimum requisite qualification.
yes.
Okay,
So she is saying by stating this, by including this in the pleadings, we have defamed her. Now, paragraph number 18, my lord, 18. So she's aggrieved by paragraph number 9 of the writ petition, some portion of the pleadings in paragraph number 9. And she's also aggrieved by paragraph number 11 of the writ petition.
11 also.
Yes, it appears in paragraph number 18 of the criminal complaint.
18, what?
The underline, if I may just read the underline.
Yes,
words.
please.
Without possessing requisite qualification as per UGC regulations and
Okay,
service rules.
okay.
Without possessing requisite qualification is the
Okay.
if the alleged imputations.
Okay,
And she's also aggrieved by paragraph number 12 of the writ petition, wherein we have stated about 80% of assistant professor posts are being held by unqualified backdoor appointees.
okay.
So 80% of assistant professor posts are being held by unqualified. That underline word.
Including the respondent.
Yes.
Okay.
So that is another one. Next is she's also aggrieved by paragraph number 16 of the writ petition. None of the respondents, the imputation is none of the respondents have the required qualifications. She's aggrieved by this, my lord. Now, if I may, for context, my lord, if I may take you to the writ petition.
None of the respondents have the required qualification. So
Yes.
those persons.
Yes, now,
Those persons 4 to 34.
yes.
Okay.
Now, for contextual and despairing lordship, I may take you to the writ petition.
Yes.
The writ petition appears at page number 205 of this additional affidavit, my lord. Two 205, my lord. My lord. I see.
Yes.
The relevant para number 9 appears at page number 228. This is WBC number
205, page number
228.
Yes. Yes, what is that?
For to understand the contextual bearings of this paragraph, I'll read the entire
Para 9.
paragraph. Yes, para 9. That by RTI reply letter bearing number such and such, dated 16 November 2022, the respondent number 3 furnished a detailed list of all the assistant professors appointed on contract basis in the government colleges, wherein a total of 158 is shown to be appointed, and out of which the petitioners are here before this court challenging a total of 32 assistant professor posts in respect of the subjects and qualifications the petitioners have. My lord, here, it starts from here. To that effect, as per the list, the respondent number 4 to 34 do not possesses the minimum requisite qualifications to hold the post as mandated by the UGC guidelines issued from time to time and the Nagaland Higher Education Services Rule 2015, wherein for the post of assistant professor, a candidate must have a good academic record with a master's degree in respective subjects with at least 55% marks, relaxable by 5% for SC/ST differently abled candidates, and must have cleared the national eligibility test conducted
NET
by
is
the.
also there.
Yes, Lordship.
NET is also there.
Yes, NET is for assistant professors
Okay.
who are supposed to be teaching in colleges, not
Okay.
State College of Teachers Education.
Mhm. Conducted.
conducted by the UGC, CISR or similar tests accredited by the state. It is pertinent to mention that the subjects in which the respondents are holding the post, the UGC conducts NET exam periodically, and as such, none of the respondents have qualified NET except for respondent number 23.
And then
She is the complainant. Respondent
complainant
number-
is the 23. You have,
Yes.
okay,
She might-
segregated her that she is having net.
NET, yes.
You have clarified.
Yes.
So this is the.
She has NET, but allow me to continue, my lord. For which the minimum, except for respondent number 23, Shrimati Roko Noso, State Assistant Professor in State College Teachers Education, for which the minimum required qualification is MET with at least 55% relaxable by such and such marks, or MA in Education with 55% marks with BEd. And she does not possess the required degree qualification to hold the post.
Okay.
So now we have stated she does not possess the required degree qualification to hold the post.
So she has MA net.
MA net.
But then require is the either MA.
MET, Masters of.
Okay, MA or MA BEd.
Yes.
But she
MA in
doesn't have a
education.
BEd, although she has a MA, but she doesn't have a BEd.
Yes, in the list, as per the list, because the writ petition was filed again as per that list. So in that list, it was depicted as, indicated as she has MA and NET, but no mention was there in for BEd, my lord.
Okay.
So because of that, we have included her as a respondent. So what I'm trying to here, what I want to stress here is that, my lord, we have stated as per the list, given by the state respondents.
Okay.
We did not say as per our knowledge, as per what we have found, but we have stated as per the list. So the case was built on the RTI reply given by the state respondents, my lord. The next paragraph is paragraph number 11, my lord. Paragraph number 11, page 230, my lord.
Paragraph
11, lordship. She's also here for contextual bearings, my lord. Allow me to read. Now here also we have stated that your humble petitioner respectfully submits that state respondents have appointed 31 assistant professors on contract basis, whereof 17 respondents were appointed after the issuance of OM 6616, enforcing ban on appointments on contract basis without qualifications. 14 respondents were appointed before the issuance of office memorandum dated 6616 without possessing requisite qualification as per UGC regulations and service rules. So she's aggrieved by this sentence without possessing requisite qualification as per UGC regulations and service rules. But the paragraph, what I'm trying to impress here is, my lord, she cannot simply take out of context some lines and then say that it is defamatory in nature. My lord, we have clearly stated in the preceding lines that we have mentioned also about Office Memorandum 6616, which put a ban. It is an office memorandum issued by the state government. So we have built our case on the RTI list. We have also built our case on the Office Memorandum 6616.
Oh, what is this office OM 616?
It is an office memorandum issued by the state government banning appointments without advertisement and without qualifications.
Yes.
Now the next paragraph is at page number 232, paragraph number 16, Manu. Page number 232, Manu.
Yes.
May I read, my lord?
Yes.
That your humble petitioners humbly submit that for all appointments, be it on contract, general advertisement has to be mandatorily made, and the qualifications and procedure for appointing them should be the same as those applicable for regular appointees. And as such, none of the respondents have the required qualifications, and none of them were appointed through advertisement by way of the normal mode of selection procedures as per law. So she is aggrieved by starting from, as such, none of the respondents have the required qualifications. If my lord has it from here till the last word, she is aggrieved by this.
Okay. So.
Paragraph number 9, 11, 12, and 16 of writ petition. The petitions appears at paragraph number 9, 11, 12, and 16. So, my lord.
Where is 12?
Paragraph number 12. Look.
12 we haven't read.
Eleven, 16. Beg your pardon, my lord. 9, 11. Yes, my lord. Paragraph number 12 is at page 230.
Yes. So here by which sentence is aggrieved?
May I read, my lord?
Yes, please.
That your humble petitioners respectfully submits that the backdoor appointments in gazetted posts in Nagaland are possible because of nexus between the bureaucrats and politicians in appointing their candidates at the cost of meritorious and qualified petitioners who are denied the opportunity to even compete in NBSC for non-requisition of advertisement of post vacancies. It is entirely, in its entirety, about 80% of assistant professor posts are being held by unqualified backdoor appointees. So she is aggrieved by the sentence. About 80% of assistant professors are being held by unqualified and are appointed without general advertisement. See, my lord. Our challenge in the writ petition was on twofold. One was without qualification and one was without general advertisement.
Okay. So her appointment was without advertisement.
Without advertisement, my lord.
Okay.
It is settled law. It is settled law that any appointment made without issuing advertisement inviting application from eligible candidates are and without holding selection process where all eligible candidates gets a fair chance to compete violates the fundamental rights of meritorious persons. For that matter, the petitioners are aggrieved and seeking relief from this honorable court so that the minutes of backdoor appointees in public employment adopted by the respondent government and its instrumentalists without following the basic procedures established in that behalf is done away with once and for all, keeping in mind equality of opportunity as the hallmark, and any appointment otherwise is biased, unfair, and discriminatory. So this is the contextual, this context we have to understand if this honorable court has to do substantial justice on reading the entire thing in its entirety, we have to understand whether my submission is that whether whatever we have pleaded in the writ petition will be imputations, will be defamatory in nature, my lord.
Yes.
So, my lord, my humble submission is that the petition was filed challenging the administrative and executive action of the respondents in appointing persons who do not possess qualification as well as without advertisement, which is mandated by the Constitution of India, Article 1416, Lordship. So we have filed the petition seeking a direction to terminate the service of respondents if found to be not at bar or if found was not done in consonance with the constitutional scheme of this country, my lord. Second, we have prayed for requisition of the posts of those posts held by respondent number 4 to 34 to NBSC for advertisement. That is a simple case of the petitioner in with petition number WBC number 340 of 2022, my lord.
Yes.
Now, my lord, my first submission, basing on all the writ petition, based on what we have, what I have shown, my lord, my first submission is that there's no prima facie case of defamation under section 499 IPC. So because, my lord, in order to attract the offense of defamation under section 449 of IPC, there has to be invitations and it must be met in the manner as provided in the provision with the intention, my lord, with the intention of causing harm or having reason to believe that the invitation made will harm the reputation about whom it is made, my lord. So the basically the ingredients of the section says that causing harm to the reputation of the person is the basis on which the offense is founded, and mens rea is a condition precedent to constitute the offense. That means, my lord, in simple terms, my lord, first we have to ascertain whether harm have been caused or likely to believe that harm could have been caused. If to go a step further, if that is established, then again the precedent requirement is whether intention was there to harm. So mens rea is very essential in this to attract the section of 499, my lord. So what we have read in the writ petition, all those paragraphs, we have clearly shown that there was no intention to harm the reputation of the respondent, because we have filed the case based on the RTI reply given by the respondent, state respondent, lordship. And my lord, in the writ petition, my lord, which is pending, the writ petition 340 of
Petition is still pending.
Yes, my lord.
Okay.
So there has been some development, lordship. In order to show that there has been no intention, my lord, by order what's that one? Yes, my lord.
So she is the respondent number 22 in that writ petition.
Yes, respondent number 23, my lord. My lord, 22.
22.
Yes, my lord, 22. After the filing of this criminal petition, my lord, after the filing of this criminal petition, my lord, the petitioners have, by order 0805/2023, have struck off the name of the respondent number 2 from the area.
So-
Now she is no longer in the petition, my lord.
Okay, but then only in the. So as per your RTI reply,
Yes,
she was only MA and
net, that was shown
Net.
to us, yes.
so, and actually she is possessing B.Ed also.
That was, that was.
That was not on record.
Yes,
So that is
that
why
was the
we
case.
treated her.
Yes, it was, it was in the writ petition earlier, which I've mentioned, my lord, WBC number 12 of 2019. In that, pleadings were completed. So in that, they have annexed their qualification.
Okay, thereafter you have made this.
Yes, yes, my
this
lord.
prayer.
Yes, yes.
And she was okay, struck off from the.
Yes.
Rate.
Yes.
Okay, now, so after that only she has filed this.
No. Before striking off her name, the
Okay,
criminal
so she
complaint.
already filed.
Yeah, she already
Now,
filed.
now, the case before the civil judge is, before which court? It is
The
pending?
criminal complaint,
Yes,
judicial magistrate, first class.
first
Kohima.
class.
Yes.
So it is still. So.
Yes, it is stayed by this honorable court.
Stayed by
Yes,
this court.
stayed, yes, my-
Okay, so now she is also pursuing. She is interested to pursue the matter
Yes.
after striking off.
Yes. Now
Subsequently, they have striked off
yes.
after knowing the fact.
The implication is twofold. But if my lord submission. Yes.
Okay, yes.
If, so now, I just want to place that on record, my lord, for
Okay.
your understanding. Lordship. No, she's no longer in the, pending writ petition 340 of 2022.
Okay.
So now, my lord, I want to, my lord, to take you to the section, relevant section. I just want to refer to 499 and 120B.
Just
My
a
lord,
minute, She was respondent.
respondent number 22 in the writ petition WBC number 340 of 2022, my lord.
She has a B.Ed.
My lord, as per what they are saying, she has
B.Ed.
yes.
Okay. Okay.
If I may take you to section 120B first, my lord, because the criminal complaint has been filed against all the 14 petitioners on the ground that there was a common criminal conspiracy for defamation. So I may take you to section 120B, my lord. Punishment of criminal conspiracy. Whoever is a party to a criminal conspiracy to commit an offense punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards shall for life or rigorous shall, where no express provision is made in this code for the punishment of such a conspiracy, be punished in the same manner as if he had abetted such offense. So the section stipulates that this section will be attracted only when the offense is punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards. Now, my lord, let me take my lord to section 500, lordship. The punishment for defamation is given under section 500, lordship.
Yes.
Punishment for defamation, if my lord has it. Whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years or with fine or with both. So the punishment here is simple imprisonment. So section 120P stipulates above punishable with death, imprisonment for life, or rigorous imprisonment for a term of 2 years or upwards. So what I'm trying to establish here is that section 120B is not attracted and could not have been inserted by the learned judicial magistrate first class. So my on a technical standpoint, my lord, my submission is that without this section, without a criminal conspiracy, how can a criminal complaint be filed against all at once? That is sweet, man. So section 120P should have been struck off, if at all, my lord. My lord, I will not take my lord to the other sections, abatement and all those might not be very much relevant, my lord. So now my next submission is, my lord, and the sum and substance of my submission is that freedom of speech and expression is a fundamental right guaranteed under Article 19(1) of the Constitution of India, my lord. So the petitioners hearing in the writ petition, while exercising this fundamental right, came before this honorable court seeking for justice or seeking for a direction to be passed to the state respondents. To advertise the post, first of all, and give them opportunity. They have approached this honorable court exercising their right to freedom of speech and expression by filing the writ petition. So, in essence, my lord, the criminal complaint, in essence, in my humble submission, my lord, in essence, is against the spirit of the Constitution, because the petitioners herein were exercising their right, their fundamental right by through their pleadings, my lord. So as custodians of fundamental rights, my lord, it is prayed that the complainant should not be allowed to undermine these precious rights of all the citizens of this country. Now, my lord, my next submission, another very important point for consideration before this honorable court is whether the JMFC had the jurisdiction to take the cognizance of the criminal complaint without a prima facie satisfaction when the matter, in essence, was seized by this honorable court in WBC number 340 of 2022, my lord. Because the matter, the substance of the issue was already before this honorable court in WBC number 340 of 2022, before she filed the criminal complaint, my lord. Because, my lord, in my humble opinion, my lord, if we have to come to a conclusion regarding the matter at hand, my lord, we have to go into whether she is qualified or not, whether what we are alleging is right or wrong. So the substance of this issue was already seized by this honorable court. This honorable court could have very well decided the matter. It had the jurisdiction. And after filing the writ petition, my lord, the writ petition was admitted and notice was issued to all the respondents. So the respondent number 22, without even appearing, without even filing her power of attorney, she went straight away to file the criminal complaint. That could have been easily avoided, my lord. They could have come before this honorable court stating that, look, this is my certificate, this is...
So I'm not a necessary party.
Yes.
Okay. Yes.
So when my lord is my lord, know more than me, but my lord, in my experience, my lord, whenever we file a writ petition, first of all, we address it to the Chief Justice and his Lord Companionships. My lord, just to indicate, my lord, I may take you to the writ petition, page number 205. Relevant page is 210. Course title, I just want to impress upon this court.
20?
210, my lord.
210.
Yes, of additional affidavit page.
Yes.
The course title, my lord, to the Honorable Mr. Justice Sergeant Such, the Chief Justice of Gauhati, Honorable Chief Justice of the Honorable Gauhati High
Yes.
Court and his lordships.
Yes.
When we file a writ petition, we file the writ petition or all the pleadings are in the confidence of the Chief Justice, my lord.
Yes.
We have never put out this pleadings or we have never stated anything about her qualification, her character, or we have never stated anything about her in the public domain, my lord. It was only within the confine of this honorable court, within the guardianship of the Chief Justice of this honorable High Court. So, in essence, what I'm trying to answer is the Leonard JMFC did not have, in no way, did not have the jurisdiction to entertain the criminal complaint when the matter, substance at issue was already seized by the Chief Justice of this honorable court. So, my lord, the complainant, by instituting the criminal complaint, has undermined the jurisdiction of this honorable court in adjudicating the matter before it.
Anything else?
Yes, my lord. Pleadings may or may not be wholly true in each case, my lord, subject to adjudication by this honorable court. But that doesn't mean that somebody can just go away, straight away, file a criminal complaint of defamation, my lord. If that would be allowed, my lord is very well aware of the doctrine of chilling effect, my lord. It will have a chilling effect in all litigants to everyone who approaches this honorable court. There has to be some breathing space, my lord, when we approach this honorable court. It may or may not be wholly true to some pleadings subject to adjudication. So, in my respectful submission, the complainant ought not to have gone to the criminal court and institute a criminal proceeding against all the petitioners when she had a remedy before the
Criminal court taken already cognizance of the case?
Yes,
Complaint? Okay, issued.
the summon order was issued.
Summon order
Yes,
issued.
without a prima facie
Okay,
satisfaction.
whether you have filed also written statement or no?
No, lordship.
No.
We after that,
Nothing.
after summon
Immediately
order.
after receipt of the summon you have.
Yes, we have
brought
come
this
for
court.
this honorable court. Yes.
Okay.
So, my lord, that is the crux of my submission. I just want to place some authorities before this honorable court in support of my case.
Okay.
My lord, first is State of Haryana and others versus Bhajanlal and others, my lord, reported in 1992, supply 1 SEC 335.
1992?
1992, supply 1 SEC 335, para number, my lord, I would just refer para number 102, my lord. The Honorable Supreme Court has
Para 102.
102, my lord. So my case will be covered by guidelines number 1, 3, 5, 6, and 7, my lord. I may be allowed to read guideline number 1, my lord. Under
Which one? 1992?
yes, 102, paragraph number 102,
Okay.
subpara 1, guideline number 1. This is the guideline, my lord. Where the allegations made in the first information report or the complaint, even if they are taken at their face value, and accepted in their entirety.
Para 10.
102, my lord.
Two.
Yes, page number 379, my lord. 378, my lord.
378. Yes. Para 102. No, 378.
Yes.
Is this the same one? No, that's supply. 335. This is R.S. Raghunathan.
No, my lord.
Raghunath
No, my lord.
versus State of Karnataka. What you have presented before me? It seems 1992 supply
One
SCC 335. It appears to be
335.
correct one, huh? 335 appears to be correct.
Yes, the relevant para is 102.
No, RS, the party name is?
State of Haryana and others versus Pajanlal, my lord.
No, just a minute. This is not the one. Is it the one?
No, my lord. What do you mean?
No, this is something else.
See.
So just confirm it. Just confirm it. It is the one referred by you.
This is one SCC of the center one, which should be submitted.
It's not supply.
Yes, this one is not supplemental. It should be. I may be allowed to refer to the other one, my lord.
So, what is the guy? Para
102.
Subpara?
Subpara 1.
What
It says that where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. The second one I'm relying is subpara number 3. It says that where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. The criminal complaint should be quashed. The next one is where the allegations, number 5, where the allegations made in the FIR or complaint are so absurd and inherently improbable on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused, the complaint or the FIR should be quashed. The next is where there is an express legal bar engrafted in any of the provisions of the Code of the Concerned Act to the institution and continuance of the proceedings, and where there is a specific provision in the Code or the Concerned Act providing efficacious redress for the grievance of the aggrieved party, where there is a remedy available, my lord. The last one is where subpara 7, where a criminal proceeding is manifestly attended with mala fide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. So, those were the guidelines. Next is, my lord.
This is State of Haryana versus?
This is State of Haryana versus Pajanlal.
Okay, Pajanlal.
The next one is just a short one.
This is 1992 supply.
Yes.
But then the list you have given is not a supply.
Yes. I beg your pardon, my lord.
Yes, get it corrected. Huh? Okay.
Next is 2023, 8 SCC 358, my lord. Para number 15, 16, and 17, my lord, I'll be reading. Fifteen, 16, and 17, my lord. I may be allowed to read, my lord.
Yes.
We are of the view that no case is made out to put the appellant to trial for the alleged offense. There is no
Para
defamation.
15.
Yes.
Just a minute. Yes. Yes.
So we are of the view that no case is made out to put the appellant to trial for the alleged offense. There is no defamation as such. Next is paragraph number 16, my lord. Exception 8 to section 499 clearly indicates that it is not a defamation to prefer in good faith an accusation against any person to any of those who have lawful authority over that person with regard to the subject matter of the accusation. Even otherwise, by perusing the allegation made in the complaint, we are satisfied that no case for defamation has been made out. So in section 499, there are 9 exceptions. So what my submission is that our case comes under the exception under section 499, particularly exception number 4 and exception number 8. I will come to that, my lord. That will be my last submission, my lord. So paragraph number 17. In the overall view of the matter, we are convinced that the appeal deserves to be allowed and is hereby allowed. The impugn orders passed by the High Court is hereby set aside. As a consequence of the same, the original order passed by the magistrate in issuing summons is also hereby quashed and set aside. My lord, my next authority is 2018, 13 ACC, 290. 2018, my lord.
Two 2018.
13 ACC, 290, my lord.
Name also right, huh? This is 2000. Okay, this is 2022. 23, 15, 16, 17. Printed copy, give us the printed copy, keep it here. All, huh? Okay, yes, this.
Yes, my lord. This case also is a short one.
2018.
Yes, 2018, 13 ACC, 290. Page number 290, my lord. Paragraph number 2 and 3, my lord. It's just basically it says that when there's no prima facie case of defamation under section 499 of the IBC, and when the basic ingredients of the section is not made out, the criminal proceeding has to be quashed and set aside.
Okay. Yes.
So on the same line, I'll cite one, I won't read, my lord. I'll just cite one case. 2010, 15 SCC 163. 2010, 15 SCC 163. Para number 2 and 3, my lord. When there is no basic ingredients, the criminal proceedings has to be quashed. That is what basically the court did.
Okay. There are 2 and 3.
Yes, madam.
2010, 15 SEC.
Yes.
What is 3?
2010, 15 SEC, page 163, para 2 and 3.
What is this para 3? Is it relevant?
Yes, my lord. Here in this case also, the basic ingredients were not made out, so that's why the criminal proceedings were quashed.
What is para 3? Let us read.
Para 3, in our considered opinion, the
No, no.
complaint.
Consider opinion. No. Which one you are reading?
2010-15 SCC 163.
163.
Yes, my lord.
No, this is 2015, 15 SSC 164.
2010-15
Okay,
SCC
163, yes.
163, my lord.
Okay, para 2 and 3. Okay.
Yes, my lord.
Yes.
So this talks about
Okay.
the lack of, when there is lack of basic ingredients, then the criminal proceedings has to be quashed as a side. Now, my lord, 2010 5 SCC. Page number 600, my lord.
Para
34, 35, 47, and 54, my lord. 34, 35, 47, and 54.
Okay. Sam.
Allow me to read, my lord. This, I want to stress a little bit on this one, my lord.
Okay. Para 34 is your
34, my lord. So para 34 says about when there is no prima facie case of defamation in the present case, my lord. So they have 34 is basically the section itself. 35, I may be allowed to read. With regard to the complaints in question, there is neither any intent. Intention is important, my lord. Intent on the part of the appellant to cause harm to the reputation of the complainants, nor can we discern any actual harm done to their reputation. In short, both the elements, mens rea and actus reus, are missing. As mentioned earlier, the appellant's statement published in India Today is a rather general endorsement or premarital sex, and her remarks are not directed at any individual or even at a company or an association or collection of persons. It is difficult to fathom how the appellant's views can be construed as an attack on the reputation of anyone in particular. Even if we refer to the remarks published in such and such, which have been categorically denied by the appellant, there is no direct attack on the reputation of anyone in particular. Instead, the purported remarks are in the nature of rhetorical questions wherein it was asked if people in Tamil Nadu were not aware of the incidents of the sex. My lord, it might not be relevant, the facts, but then the observation, the discussion here regarding the mens rea and actus reus in paragraph 35 is relevant, my lord. Next is paragraph number 47, my lord.
Yes.
My lord, 47, I will also skip, my lord. I will read only the conclusion, my lord. The conclusion. Paragraph number 54. In conclusion, we find that the various complaints filed against the appellant do not support or even throw a prima facie case for any of the statutory offences as alleged. Therefore, the appeals are allowed and the impugned judgment and order of the High Court dated 30/4/2008 is set aside. The impugned criminal proceedings are hereby quashed. Lastly, this is judgment 2020 SEC online, Matras 978, my just for my lord's reference, my lord. Okay. Para number 14, 20, 25, 26, and 28.
Yes.
On this is on my submission on freedom of speech and expression. Para number 14, I may be allowed to read, my lord.
Para 14?
Yes.
Yes.
The Honorable Division Bench of the Madras High Court, comprising their lordships, Chief Justice A.B. Shah and Justice Prabha Sri Devan in R. Raja Gopal versus J. Jayalalita AIR 2006 Madras 312, laid down the principles as follows. Thus, law is well settled that so far as government, local authority, and other organs and institutions exercising governmental powers are concerned, they cannot maintain a suit for damages for defaming them. In the case of public officials, the remedy of action for damages is simply not available with respect to the acts and conduct relevant to the discharge of their official duties. And this is so even where the publication is based upon the facts and statements which are not true unless reckless disregard for truth. This is important. In such a case, it would be enough for the defendant, member of the press or media, to prove he acted after a reasonable verification of the facts. It is not necessary for him to prove that what he has written is true. Only a reasonable verification of the facts is necessary. That's what it was held. Next paragraph is, my lord, I want to read paragraph number 20, my lord.
So the same.
Paragraph number 20, my lord.
Yes.
May I read, my lord?
Yes.
What must be seen is whether the subject matter is a public question or not. Exception number 3 to section 499 IBC refers to public question. Of course, the said expression has not been defined anywhere, including the law lexicons, but one can safely understand it to mean an issue in which the public or the community at large has a stake or interest. Media ought to be relieved from any criminal prosecution once it is noted that its case falls within the exception as delineated above. My lord, what I'm trying to, by this paragraph, what we can understand, my lord, what I understand is, since the respondent is an assistant professor, is a government servant, she should also be subjected to some judicial review, if there are reasons to do so, my lord. So exception 3 talks about where it involves public question, my lord. I may be allowed to read paragraph number 23, my lord. 25, my lord. 25. When the media is accused in a criminal defamation proceeding in a trial court, one remedy open to it is to move the High Court under section 482 of CRPC. This provision pertains to the inherent powers of the High Court to make such orders to prevent abuse of the process of any court or otherwise to secure the ends of justice. Most of the legal provisions conferring power are couched in a permissive language, but there is something called ethical imperative. It envisions that inherent powers go with implicit duties. Courts often nudge and remind the executive that possession of power is coupled with a duty to exercise the same. Judicial power can be not different. When freedom of press, which is a fundamental right, is at stake, higher judiciary is obliged to exercise not only its inherent power, but also exert itself a bit. An unused power is a useless stencil. There is no point in merely saying that press is the foundation of democracy. My lord, the last paragraph is paragraph number 26. I will just read the relevant portion, my lord. Last 4 lines. Such an activist role will have to be played by the higher judiciary because it is a matter of record that criminal defamation proceedings have become a tool of intimidation and before corporate bodies and powerful politicians whose pockets are tunnel deep and whose hands are long enough, even media houses having good resources have capitulated, my lord. So, my lord, in conclusion, my humble submission is that the complainant, hearing the respondent number 2, should not be allowed to use a criminal case to twist the arms of the petitioners when they were rightfully exercising their freedom of speech and expression in approaching this honorable court. I humbly pray that substantial justice should be made out to the petitioners. And, my lord, If the criminal proceeding is allowed, if by allowing the criminal proceeding to proceed, my lord, substantial justice will be done or not, my lord. That is my humble submission, my lord. Subject to what my learned friend says, I may take some time also.
So we'll hear next state.
Lordship, can we have it tomorrow?
Tomorrow? The tomorrow list already prepared. Next week? Next Tuesday? Monday also, I think list prepared. Monday not yet prepared.
Not yet, my lord. Monday not
So
yet.
then Monday?
Yes, my lord.
Monday, I have another.
Okay, Monday or any day?
Tuesday.
Tuesday, okay. You are Mr. Abe, I mean. Mr. Abe.
No, lordship.
No, you are?
Tushi All Kumar, lordship. Tushi All Kumar.
Okay. Or Mr. Tusi?
All Kumar, lordship.
Okay, Land Council for the petitioner. The petitioners, huh? Also, Mr. Irado, El Irado, Land Council for the respondent number 2. No, Mr. Jimomi, Mr. V. Jimomi, Land PP for the state, and Mr. El Irado, Land Council for the respondent number 2 staff. List is matter on Tuesday for further hearing, huh? Okay. Age agreed upon by the parties, huh? List is matter on Tuesday. Tuesday is what date?
It's on 4th.
4th, okay, on 4th, huh? For further hearing. Okay.
Obliged, my lord.
What is that matter about? Okay. So,
Orders item number 18.
okay. No one appears on behalf of the parties. Huh? The matter stand adjourned. List is matter after 3 weeks. Okay.